Okay, welcome everybody. Today is volume 2 of the Trust Architecture volume 2 and how to design, layer, and sequence trusts without collapse. Important notice, scope and intended use. This ebook is part of the Private Foundations and Risk Literacy series. The live YouTube sessions associated with this series are provided for general educational literacy only and are designed to help viewers understand administrative systems, terminology, and common sources of confusion. This ebook goes beyond the scope of the live sessions. It contains structured analysis, sequencing explanations, and reference material that is not presented publicly and is intended solely for members who have agreed to the Private Membership Association terms. This material does not provide legal advice, tax advice, or instructions for filing. It is designed to support informed decision-making and to reduce harm caused by misunderstanding administrative processes. Private membership use only. Access to this ebook is limited to members of the Private Path Membership Association who have completed the membership application, agreed to the association agreement, and executed the non-disclosure agreement. Redistribution, exerting, or using of this material outside the PMA is prohibited. This restriction exists to ensure that material is studied in its proper context and is not misapplied, misquoted, or used without adequate foundational understanding. The YouTube series teaches literacy. The ebook exists so students don't misapply what they learn. Disclaimer and educational notice. This ebook is provided for educational and informational purposes only. It does not constitute legal, tax, or financial advice, and it should not be relied upon as such. This material in this publication is based on private research, historical references, and educational analysis, including concepts taught by Patrick Devine as interpreted and expanded upon by Private Path HR Solutions. The purpose of this work is to explain administrative classification, presumptions, and common sources of misunderstanding, not to instruct readers on filing, compliance avoidance, or legal strategy. Readers are solely responsible for their own decisions, actions, filings, and outcomes. No guarantees, express or implied, are made regarding results. For matters requiring professional judgment, readers are encouraged to consult a qualified, licensed professional in the appropriate jurisdiction. Private Membership Association Notice. This publication is a private educational resource made available exclusively to members of the Private Path HR Solutions Private Membership Association. Access to this material is conditioned upon acceptance of the PMA and non-disclosure agreement. Use of this publication is limited to personal educational study by authorized members. Unauthorized sharing, reproduction, distribution, or commercial use of this material, whether in whole or in part, constitutes a breach of private contract and may result in remedies available under the PMA agreement, including termination of membership and pursuit of contractual or civil relief where appropriate. Copyright and use restrictions. Copyrighted 2025, Private Path HR Solutions, PMA, all rights reserved. No part of this publication may be reproduced, stored, transmitted, or distributed in any form or by any means without prior written permission, except for brief quotations used for private study or commentary within the PMA. References to government agencies, including the Internal Revenue Service, are descriptive and educational only. Nothing in this publication instructs or encourages evasion of lawful reporting or compliance obligations. You can contact us if you have any questions, need guidance, or wish to access additional tools and consulting. Visit our website at www.privatepatHRsolutions.com or our email at privatepatHRsolutions@gmail.com. And if you want to join our classes, send an email to classes@privatepatHRsolutions.com. We are also on Instagram and TikTok at privatepathr, and you can do our private membership access available through our site. And if you're watching us on YouTube Live tonight, make sure to comment classes as well as like and share and subscribe. Okay, here we go. Introduction, where trust architecture ends and governance begins. This volume is part of the Private Foundations and Risk Literacy series. Its role is precise: to teach how trusts must be designed so they do not collapse once they are used. Trust architecture focuses on function, separation, design discipline, and structural coherence. It does not attempt to teach day-to-day administration, record-keeping, or operational governance. That function belongs elsewhere. Introducing the family office. As students progress through trust architecture, a consistent realization emerges. Even a properly designed trust can fail if it is operated without governance. This is where the Family Office series becomes relevant. The Family Office is not part of the trust architecture volumes, and it is not a trust itself. It is a separate educational series focused on governance. In practice, the Family Office coordinates activity across trusts and entities. It maintains administrative discipline, preserves separation between personal life and fiduciary action, and prevents trusts from being misused as operating alter egos. Trust architecture teaches what should exist. The Family Office teaches how to manage what exists without collapsing it. Why this matters before the Patrick Devine series. The advanced work associated with Patrick Devine assumes that the student already understands how their trusts are structured, which trust does what, where activity belongs, and how authority is documented and governed. Without that foundation, students often misuse trust as operating tools, assert authority without records, attempt remedy without coordination, and collapse otherwise valid structures. For that reason, the Family Office series is introduced here as a necessary governance layer to be completed before moving into Patrick Devine's level education. This is not sequence mandate, it is a readiness clarification. And just for you know, we are going to be announcing soon the Family Office series. So if you're interested in taking part of the Family Office series, make sure to join our website and become a member of the website, so that way you're first in line to start that class. We will be starting that probably by the end of March, beginning of April. What this volume does and does not do. This volume teaches architectural thinking, explains functional separation, prevents structural collapse, and prepares the student for governance. This volume does not teach daily administration, replace governance systems, or attempt to manage activity. That distinction is intentional. All right, here we go. Part 1, Architectural Foundations. Chapter 1, Why One Trust Does Everything Always Fails. The most common mistake made by students entering the private trust space is not a legal error. It is a design error. Most people assume that if a trust is lawful and private, it can safely be asked to do everything. Specifically, they believe that a single trust can hold assets, operate businesses, contract publicly, pay individuals, shield liability, serve as an estate vehicle, and act as a governance mechanism. This belief is attractive because it promises simplicity. It is also the fastest way to collapse an otherwise lawful structure. This chapter explains why trusts fail when they are forced to perform incompatible roles, and why structural collapse almost always occurs before legal trouble ever appears. The insight here is that most trust failures do not begin with enforcement. They begin quietly with structure. Trusts are functional instruments, not containers. A trust is not a storage unit. A trust is a legal relationship defined by purpose, its authority, the duties, and its limitations. Every trust is created to perform a specific function. When a trust is treated as a container for everything, it loses functional clarity, fiduciary integrity, and defensive posture. At that point, the trust stops behaving like a trust. It becomes an alter ego. Plain language analogy. A trust is more like a tool than a box. A hammer works well as a hammer, but it fails as a screwdriver, a saw, and a wrench. When students try to use one trust for everything task, the trust doesn't become stronger, it becomes unusable. Why function determines exposure. Different trust functions carry different risks. And administrative functions require neutrality and restraint. Holding functions require passivity and insulation. And operating functions invite contracts, liabilities, and public scrutiny. When these functions are combined into a single trust, you have liability flows freely, asset protection erodes, classification becomes unstable, and fiduciary roles blur. This is not a drafting flaw, it is an architectural failure. The key insight here is that exposure is not created by activity alone. It is created when activity occurs in the wrong structural place. How one trust structures collapse in practice. One trust does everything structures usually collapse in predictable ways, not dramatically, but gradually. Reclassification. The trust begins to look less like a fiduciary vehicle and more like a business or personal alter ego. Piercing. Control, benefit, and activity unify, making assets reachable. Administrative contradiction. Banking, contracts, and filings are no longer aligned with the trust's stated purpose. None of these outcomes require bad intent. They arise naturally from conflicting functions. Most students are shocked when problems appear later, not because they acted improperly, but because the structure could not support what it was asked to do. Why this mistake is so common. This error persists because templates encourage consolidation, gurus reward speed over understanding, students equate complexity with protection, and one document feels safer than many roles. But architecture does not work this way. You would not route electrical, plumbing, and load-bearing systems through a single beam. Likewise, you cannot route identity, assets, authority, and activity through a single trust. The system doesn't punish intent. It responds to patterns, and poor architecture creates bad patterns. The core architectural principle of this volume is built on a single foundational principle. Protection comes from separation of function, not from the number of trusts created. A sound structure may require one trust, several trusts, or no trusts at all. What matters is not quantity, it is clarity of the role. This volume does not teach people to add more, it teaches people to separate correctly. In closing, why simplicity without separation is fragile. Simplicity is not the enemy. Oversimplification is. A single trust can be appropriate only when its function is narrow, its activity is limited, and its authority is disciplined. The moment a trust is asked to operate, contract, pay, govern, shield, and inherit, collapse becomes a matter of when, not if. This volume exists to prevent that collapse before it becomes expensive, visible, and irreversible. Chapter 2, Administrative Trusts versus Holding Trusts versus Operating Trusts. Why function must be defined before drafting. After understanding why one trust does everything fails, the next correction is to understand function. Trusts are often discussed as if they were interchangeable. They are not. Each trust type exists to perform a specific role, and problems arise when those roles are blurred. This chapter defines the three primary trust functions used in sound architecture. You have administrative, holding, and operating. The objective is not to multiply trusts, but to assign roles correctly. The framing insight is drafting before defining function is like building walls before deciding what the room is for. Think of trust architecture like a building. The administrative layer is the planning office. The holding layer is the vault. And the operating layer is the storefront. Problems occur when the vault starts selling products or when the storefront controls the blueprints. A common real-world scenario. A student creates a trust to hold everything. At first, nothing goes wrong. The bank account opens, the EIN is issued, and the structure feels quiet and safe. Months later, the trust signs a contract, pays a contractor, receives income, and holds assets at the same time. No alarms go off immediately, but later, when banking questions arise, when a filing is triggered, or when a dispute occurs, the trust is treated as one unified thing, owner, operator, and beneficiary. At that point, the student asks the wrong question. What did I do wrong legally? The answer is nothing. The failure was the architecture. Administrative trust, the neutral layer. Purpose: an administrative trust exists to administer, not to transact. The core characteristics is neutral posture, record keeping and coordination, fiduciary oversight, and minimal external engagement. What it should do is maintain minutes and resolutions, hold non-operational authority, coordinate decisions across structures, and preserve separation between roles. What it must not do is operate businesses, contract with third parties, receive operational income, or act as a personal proxy. Why this causes panic later? When an administrative trust starts operating, students often don't realize it until correspondence arrives. At that point, they are forced to explain behavior that never should have existed in that layer. Holding trusts, the asset layer. Its purpose is a holding trust exists to own and hold assets passively. Its core characteristics is assets ownership without activity, insulation from operational risks, limited decision-making scope, and long-term posture. What it should do is hold title to assets, license or lease assets to operators when appropriate, preserve asset continuity, and remain passive. What it must not do is run businesses, employ people, pay vendors, or engage in daily operations. Why this causes panic later? When a holding trust pays expenses or hires people, asset protection disappears quietly, long before anyone notices. And the key insight here is that assets are safest when they are separated from the noise of activity. Operating trust, the activity layer. Its purpose? An operating trust exists to engage in activity. The core characteristics are contracts and transactions, revenue and expense flows, public-facing posture, shorter time horizons. What it should do is operate a business or project, enter contracts, pay vendors and workers, and accept operational risk. What it must not do is hold assets unnecessarily, govern unrelated structures, serve as an estate vehicle, or collapse into personal use. Why this causes panic later? When an operating trust holds assets or governs other entities, liability concentrates instead of dispersing. Activity belongs where liability is expected, not where assets are preserved. Why mixing these functions causes collapse? Give me one moment. When administrative, holding, and operating functions are mixed, liability flows without barriers. Banking posture becomes contradictory. Classification becomes unstable, and fiduciary capacity is compromised. This is not theoretical. It is observable in piercing analysis, reclassification disputes, and banking and compliance breakdowns. Separation is not complexity for its own sake, it is containment. An important reminder is that collapse is usually delayed. That delay is what makes the mistake dangerous. Choosing the right function without adding trust. A critical insight for students is this: you do not always need another trust. You need the correct function to exist. In some cases, an administrative function can be handled by governance. Example given, a family office. An operating function belongs in an entity, not a trust. A holding function may be unnecessary if no assets require insulation. Architecture begins with needs, not documents. Structure should respond to reality, not to templates. How this aligns with the advanced private education. Advanced private education, particularly work associated with Patrick Devine, assumes that functions are already separated, authority flows cleanly, assets are insulated, and operations are contained. When students skip functional separation, advanced concepts are misapplied and fail in practice. This chapter provides the functional vocabulary required to proceed correctly. Caveat: more structure does not mean better structure. An educational clarification: adding trust without defining function increases confusion, multiplies contradictions, and weakens protection. Sound architecture is minimal, intentional, and disciplined. In closing, why function is the first design decision. Before drafting language, filing forms, or opening accounts, one question must be answered: what function must exist and where does it belong? Administrative, holding, and operating trusts are not interchangeable. They are tools with distinct purposes. When each tool is used correctly, structures stabilize. When they are misused, collapse follows. Another caveat: correct sequencing in the Patrick Devine framework. In the framework taught by Patrick Devine, the 98 EIN Birthright Trust is the first trust created, and we call it the Birthright Trust just to give it something that people can follow. This trust is established before any banker or operational structures. It serves as the fiduciary anchor for the estate and provides administrative interface through an EIN. It is not designed to operate, hold business assets, or deliver services. The estate exists as the source of authority, but the 98 Trust is the first formal fiduciary instrument placed into use. Misunderstanding this sequence leads students to create banker trust prematurely, operate through the 98 Trust, collapse fiduciary and operational roles, and destabilize downstream structures. This volume does not change Patrick Devine's sequence. It explains where activity must not be placed once that sequence exists. The additional structures introduced in this series, the holding trust, trust management companies, and private membership associations, exist to preserve the integrity of the 98 Trust, not to replace it. Chapter 3: Estate-Based Trust Logic and the Origin of Authority. Why students get stuck here. This is the point in private education where most students freeze. They hear two statements that appear to contradict each other. The estate is the origin of authority. The 98 EIN Birthright Trust is created first. Without context, students try to resolve this by choosing one and rejecting the other. That choice creates confusion before any paperwork is even touched. This chapter exists to resolve that tension, not by redefining terms, but by placing them in the correct order. Why authority exists before paperwork. One of the most persistent errors in private trust education is the belief that authority is created by documents. It is not. Authority exists before paperwork. Documents merely express authority in a form systems can recognize. This chapter explains what the estate actually is, why it is the origin of authority, why the 98 EIN Birthright Trust is created first administratively, and how students misplace authority and collapse structure before they begin. Understanding this distinction is essential before discussing any layering, banking, or remedy. A critical distinction. In this chapter, two ideas must be held at the same time. Something can exist conceptually before it is expressed administratively. Systems require instruments even when authority already exists. Failing to separate these ideas is the single most common reason students misplace authority. What the estate actually is and is not. Before any trust exists, before any EIN is issued, before any document is signed, something already exists that law recognizes. That something is the estate. The estate is not a trust document, a filing, a bank account, or a registered entity. The estate is the totality of rights, interests, and property associated with a person recognized by law. It exists by operation of law in the sense that property rights and legal interests are recognized independent of whether formal instruments have yet been created, regardless of paperwork, regardless of filings, and regardless of awareness. This is why the estate cannot be created in the same way a trust is created. It already exists. Why authority originates at the estate level. Authority flows from ownership and interest, not from administration. The estate represents the origin of beneficial interest, the source of standing, and the basis for fiduciary capacity. A trustee does not have authority because a document says so. A trustee has authority because they are acting on behalf of the estate. This is the logic that underpins fiduciary law, executor authority, trustee responsibility, and standing in equity. Without an estate, there is nothing to administer. Why the estate is not the first instrument created. Although the estate is the origin of authority, it is not the first instrument created in practice. Why? Because the estate does not transact, does not interface administratively, it does not receive an EIN, and it does not open accounts. Systems require an administrative vehicle to interact with. That vehicle is the 98 EIN Birthright Trust. What goes wrong in practice? Students who hear the estate comes first often try to operate through the estate. When the systems require an interface, they either freeze and do nothing or misuse the estate as if it were an administrative entity. Both paths create confusion. The estate is the source of authority, but it is not the vehicle that interacts with systems. The role of the 98 EIN Birthright Trust, administratively first. Think of the 98 Trust this way. The estate is the source. The 98 EIN Birthright Trust is the interface. Authority flows from the estate. Administrative systems recognize the trust as the formal fiduciary interface. In the framework taught by Patrick Devine, the 98 EIN Birthright Trust is the first trust created and used. Its function is specific and narrow. It acts as the fiduciary administrative expression of the estate. It interfaces with systems using an EIN. It provides a recognizable fiduciary administrative interface for commercial interaction and remains non-operational. This trust does not operate businesses, hold operational assets, deliver services, or replace the estate. It represents the estate administratively. This distinction resolves the confusion between estate first and 98 trust first. Both are true in different ways. Conceptual first and administrative first, or conceptual first versus administrative first. This resolves the apparent contradiction. When students finally understand this distinction, confusion dissolves. The estate is conceptually first. The 98 trust is administratively first. Both statements are true because they describe different functions. This is the distinction students must understand. Conceptual first is the estate. It exists by law. Administrative first, the 98 EIN Birthright Trust, is first instrument used. Problems arise when students reverse these roles by trying to operate through the estate or treating the 98 trust as the estate itself, or forcing business or assets into the 98 trust. This misplacement collapses fiduciary posture. How authority is commonly misplaced. Authority is misplaced when students treat the 98 trust as an operating entity, assign assets directly to administrative trusts, skip fiduciary record keeping, or assert authority without governance, collapse beneficiary, trustee, and operator roles. These errors do not negate the existence of authority, they misuse it. Misused authority attracts scrutiny and undermines structure. Why this matters before layering. Layering trusts without understanding authority leads to redundant structures, contradictory roles, alter ego findings, failed banking relationships, and broken fiduciary chains. Before asking how many trusts are needed, a student must understand where authority begins and where it must stop. This chapter ensures that clarity exists before additional layers are introduced. Caveat: authority is not activated by assertion. This is an educational clarification. Authority is not activated by declarations, notices, status claims, or self-designation. It is activated by capacity exercised correctly on behalf of the estate. Documents express authority. Conduct proves it. In closing, why correct origin prevents structural collapse. When authority is correctly understood, the 98 trust remains administrative, banking structures stay contained, assets are placed deliberately, operations occur in the correct layer, and remedy is not attempted prematurely. When authority is misunderstood, trusts are overloaded, layers contradict each other, and students chase corrections instead of building stability. This chapter exists to prevent that outcome. Why this must be understood before anything else. Every structure that follows, banking, layering, operations, remedy, assumes this clarity. When authority is placed correctly, structures stabilize. When it is misplaced, students chase corrections instead of building systems. This chapter exists so the next chapters can be read correctly. Part 2, Structure, Separation, and Risk. Chapter 4, Separation of Identity, Assets, Activity, and Authority. How to read this chapter. This chapter introduces 4 concepts that must remain distinct for any private structure to function: the identity, assets, activity, and authority. These are not legal theories. They are separation boundaries. Most students do not collapse these intentionally. They collapse them gradually, often without realizing it, until the structure no longer behaves as a trust at all. Why most trust structures collapse quietly. Most trust structures do not fail loudly. They do not fail because of criminal conduct, invalid documents, immediate enforcement. They fail quietly through role confusion. This chapter explains the 4 elements that must remain separate at all times. For a trust structure to remain stable, you have identity, assets, activity, and authority. When any two of these collapse into one place, the structure becomes fragile. When 3 collapse, failure is inevitable. One mental model to hold throughout this chapter. Imagine 4 separate lanes on a roadway. Your identity is who, your assets are what, your activity is what happens, and your authority is why it is allowed. Problems arise when traffic drifts between lanes. Identity. Who is acting? Identity answers the question, who is the actor in the system? The identity includes the natural person, fiduciary, trustee, manager, officer, or member. The key rule here is identity must be consistent, not convenient. Common identity failures is acting personally while claiming fiduciary protection, or using personal emails, accounts, or signatures for trust activity, or switching identities mid-transaction. When identity blurs, the system defaults to the individual. Why this fails quietly? Identity collapse rarely creates immediate problems. It becomes visible only when documents, banking, or correspondence begin to contradict each other. Assets. What is being protected? Assets answer the question, what is being owned, held, or preserved? Assets include real property, intellectual property, equipment, financial reserves, or long-term holdings. The key rule here is assets must remain passive to stay insulated. Common asset failures: holding assets in an operating structure, using administrative trust to own operational property, or commingling personal and trust assets. When assets become active, insulation disappears. Why this fails quietly? Asset commingling often appears efficient until ownership and liability are questioned at the same time. Activity. What is being done? Activity answers the question, what actions are occurring? Activity includes contracting, selling, consulting, employing, or transacting publicly. The key rule here is activity must be contained, not distributed. Common activity failures: operating businesses through the administrative trust, delivering services directly from holding trust, or using trust as personal payment conduits. Activity attracts scrutiny. That is not a flaw. It is its nature. Why this fails quietly? Activity placed in the wrong structure often works until someone asks, who is responsible? Authority. Who has the right to decide? Authority answers the question, who has decision-making power and why? Authority flows from a state origin, fiduciary appointment, governing instruments, and documented capacity. The key rule is authority must be exercised, not asserted. Common authority failures are self-appointment without records, acting without minutes or resolutions, and confusing control with ownership. Authority without discipline is treated as personal control. Why this fails quietly? Authority confusion usually appears only after something goes wrong and justification is demanded. Why students commonly reverse the order? Students are often taught to start with paperwork. This leads them to focus on entity names, EINs, documents before understanding function. When paperwork leads, separation follows the document instead of the reality. This reversal is the source of most structural contradictions. How collapse happens, the compression effect. This is where structure becomes stable. Separation does not mean isolation. Identity, assets, activity, and authority can interact, but only when their boundaries are respected. Collapse occurs when identity and activity merge. That creates an alter ego. Assets and activity merge. That creates exposure. Authority and identity merge. That creates a personal liability. All four merge is total structural failure. This compression often happens unintentionally through convenience. Systems respond to what is observable, not what is intended. Why this matters in the Patrick Devine framework. The work associated with Patrick Devine assumes that the fiduciary capacity is respected, administrative trusts do not operate, authority is exercised through record keeping, and identity remains consistent. When students collapse the four elements, the 98 trust is misused, banker trusts are overloaded, remedy is attempted without standing, and enforcement fails in practice. This is not a doctrinal problem. It is a structural discipline problem. The role of governance in preserving separation. This chapter intentionally exposes the need for governance. Separation is preserved through minutes and resolutions, clear role assignment, delegation structures, oversight, for example, a trust management company or a family office. Without governance, separation collapses under pressure. Caveat: separation is a daily practice, an educational clarification. Separation is not achieved by documents alone. It is maintained through daily conduct. Most collapses occur not at formation, but at use. In closing, why separation is the real protection. Trust documents alone do not protect assets. Structural separation protects assets. Trusts do not create authority. Discipline preserves the authority. When identity, assets, activity, and authority remain distinct, your structures will stabilize, banking relationships will survive, fiduciary posture will hold, and advanced remedies remain viable. This chapter is the line most students cross without realizing it. Chapter 5, Naming, Discipline, and Alter Ego Risks. Why names matter more than most people realize. Most students underestimate the power of names. They believe names are cosmetic, names are symbolic, or names are private preferences. In reality, names are signals. They signal relationship, control, unity of interest, and continuity between persons and entities. This chapter explains why poor naming discipline collapses separation, triggers alter ego analysis, and undermines trust protection, even when documents, EINs, and structures were otherwise correct. Why this chapter matters more than it appears. Many students believe that structure fails because of bad filings, bad actors, or enforcement. In practice, many structures fail much earlier, at the naming stage. Names are often chosen casually, copied from templates, or selected for symbolism. But to administrative systems, names are not symbolic. They are pattern indicators. This chapter explains how naming collapses otherwise sound structures and why alter ego risk is most often created by names, not actions. Important clarification. Alter ego determinations are not moral judgments. They are pattern conclusions. Systems do not ask why names were chosen. They observe how identity, control, and benefit appear to unify. What alter ego actually means. An alter ego is not a criminal accusation. It is an analytical conclusion. Alter ego analysis asks, is the entity functionally indistinguishable from the individual controlling it? Indicators include same naming conventions, same addresses and contact points, same signature styles, same accounts and payment flows, and same behavior across roles. When the answer appears to be yes, separation collapses. How collapse happens quietly. A student uses the same personal name across an administrative trust, a holding trust, an operating structure, and personal correspondence. No single document creates a problem. Over time, however, the pattern suggests a single controlling identity. Alter ego risk emerges not from a mistake, but from repetition. Why naming errors persist. Naming discipline is most often lost not through intent, but through imitation. Students rarely invent problematic naming patterns on their own. They copy them. This usually occurs when a document or structure is presented as working. A template is reused without context, or symbolic naming is mistaken for protection. In these situations, names are selected for familiarity or consistency, rather than for separation of function. What feels orderly to the student often appears unifying to administrative systems. Alter ego risk emerges not because the structure is unlawful, but because naming signals collapse boundaries that the architecture was meant to preserve. Why names are treated as evidence. Names are not neutral labels. In administrative, banking, and legal systems, names are used to trace relationships, identify continuity, detect commingling, and infer control. When entities share personal names, variations of the same name, all caps formats mimicking individual identity, or doing business as chains tied to one person, the system infers unity, not separation. Intent does not override appearance. Common naming errors that create alter ego risk. The following errors appear repeatedly in collapsed structures. Personal name duplication, using the individual's full name or close variations across the trusts, operating entities, and administrative structures. The estate name misuse, using estate style names for operating or banking activity, mirror naming, and creating multiple entities with nearly identical names, differing only by trust, holdings, management, or bank. Over-descriptive naming, names that attempt to declare purpose or status instead of remaining neutral. Each of these errors creates traceable continuity. Naming versus function, the critical disconnect. A properly designed structure separates function, authority, activity, and assets. But careless naming reunifies them symbolically. For example, an administrative trust with a personal name, a holding trust named after the same individual, and an operating entity using the same base name. Even if functions are different on paper, names collapse them in perception. Perception controls scrutiny. Why this matters in advanced private frameworks. In the work associated with Patrick Devine, the distinction between the individual, the estate, the fiduciary, and the trust is foundational. When naming collapses those distinctions, fiduciary posture weakens. Standing becomes vulnerable. Administrative neutrality disappears, and remedy becomes harder to sustain. This is not because the theory is wrong, it is because the presentation contradicts the theory. Naming discipline as a form of risk management. Naming discipline is not about secrecy, it is about clarity without continuity. Sound naming principles include neutrality over personalization, functional reference over identity reference, distinction without mimicry, and consistency without sameness. Names should support separation, not undermine it. Why renaming later rarely fixes the problem. Once accounts are opened, contracts are signed, and records are created, renaming does not erase history. Earlier names remain part of the record trail and are often discoverable. This is why naming discipline must exist at design, not after problems arise. Educational example. Naming trust correctly within the Patrick Devine framework. One of the most common ways students collapse otherwise valid trust structures is through careless or imitative naming. In the framework taught by Patrick Devine, names are not used to assert status, declare sovereignty, signal exemption, or mimic personal identity. They are used to express function and fiduciary relationship while preserving separation from the individual. The examples below illustrate lawful, disciplined naming logic consistent with Patrick Devine's teachings and extend safely by this series. Number 1, the Birthright Trust. The 98 EIN is an administrative fiduciary anchor. Its purpose is first trust created administratively, fiduciary interface for the estate. It's non-operational and non-personal. The correct naming logic references the estate, not the living individual. It avoids personal name dominance and avoids DBA-style business naming and does not imply operation, commerce, or services. Educational example is the estate of name, Birthright Trust, name, estate trust. The trust of John Henry Doe, Birthright Trust, is an example. What matters is not the exact phrasing, but that the estate is central, the trust is clearly fiduciary and administrative, and the individual's living persona is not presented as the actor. The common error is that somebody puts the first last name and then just trust. This collapses identity and creates alter ego appearance. For example, the John Henry Doe Trust. This collapses identity and invites alter ego analysis. Number 2, estate trust, conceptual versus instrumental clarification. In Patrick Devine's framework, the estate exists by law. The 98 Birthright Trust expresses it administratively. Some students create a separate estate trust instrument later for specific purposes. If they do, naming must remain estate-centric, not personal. Correct naming logic would be estate-based, neutral, and non-operational. Estate is the original of the authority. The Birthright Trust is the first administrative expression of that authority. Names must reflect this distinction or separation collapses. Private banker, private individual banker trust. Purpose. Its financial interface only, receives and disperses funds, no asset holding, and no business activity. The correct naming logic is functional, not personal. It does not reuse the estate name directly, and it does not resemble a business brand. So for the educational example, you're going to use a neutral name, fiduciary banking trust, for example. The key is that the name does not imply ownership, the name does not mirror the individual, and the trust's role is instrumental, not foundational. The common error is using the individual's full name plus bank at the end, or using the same root name as the 98 trust. Holding trusts. Its purpose is passive ownership of assets. Firewalls between assets and activity. The correct naming logic is asset neutral, function specific, and no personal identity markers. An example is neutral term, holdings trust. Common error is naming holding trust after the individual or the estate, or using family or personal branding that signals unity of interest. Trust management company. Its purpose is governance, administration, fiduciary oversight, and record keeping. Correct naming logic would be managerial, not personal. Clearly separate from trusts it manages, and does not imply ownership of assets. The educational example is, it's a neutral name, trust management company. The critical rule is that the TMC manages trust, it does not become them. The common error is using the same name as the trust being managed. Private Membership Association, or PMA. The purpose is education, consulting, services, and membership activity. The correct naming logic would clearly not be a trust, clearly not estate-based, and no personal name dominance, no fiduciary implication. Educational example is distinct name, Private Membership Association. For example, Private Path HR Solutions is a PMA. Why this matters? It keeps services out of trust, prevents trusts from being treated as operating businesses, and preserves fiduciary neutrality. The common error is running the PMA activity through the 98 Trust or a banker trust. Why this matters administratively. Alter ego conclusions do not require enforcement. They affect how records are interpreted, how explanations are evaluated, and how inconsistencies are resolved. Most students encounter the consequences only when something else triggers review, often much later. Key naming principles for students. Naming is architecture, not decoration. Names do not create authority, but they influence how authority is perceived. When naming collapses identity, structure collapses with it. This chapter exists to ensure that separation achieved in earlier chapters is not undone by carelessness. Once naming discipline is understood, the next challenge becomes managing scale and complexity without creating the same risks. In closing, trust architecture is not built through documents alone. It is communicated through structure, function, and observable separation. Names are part of that communication. When naming reflects role, capacity, and layer distinction, the structure reads clearly. When naming collapses into imitation, duplication, or symbolic labeling, the architecture weakens. Separation is rarely defeated through dramatic error. It erodes quietly through small signals that accumulate. Chapter 5 has emphasized that naming is not cosmetic, it is evidentiary. Before moving into banking behavior and institutional interaction, one principle should remain clear. If the structure is sound but the signals are blurred, the structure will be interpreted through the blur. Disciplined architecture requires clarity at every level, including the name. Architectural clarification, naming conventions and structural signals. Within certain private education frameworks, students often adopt standardized naming patterns across multiple trusts. This may include appending designations such as the FGT, Foreign Grantors Trust, to a trust name, or repeatedly using the same personal name across administrative, estate, and financial trust layers. For example, the full name and the estate, or full name FGT, or full name Private Banker Trust. From an architectural perspective, naming carries structural implications. A trust tax classification is not determined by its title. Whether a trust is domestic or foreign is determined by statutory tests concerning jurisdiction, control, and administration. Labeling a trust FGT does not establish foreign status, nor does it control reporting or classification outcomes. Classification follows legal analysis, not abbreviation. Similarly, repeating the same name across every trust layer may unintentionally weaken separation signals. When administrative estate and financial interfaces appear visually unified, pattern analysis may interpret continuity rather than distinction. Naming should reflect structural function, not tax theory or educational lineage. Disciplined architecture prioritizes functional clarity over symbolic labeling, deliberate separation between trust layers, restraint in estate-centric duplication, and administrative precision rather than branding signals. Trust structure is evaluated through observable patterns. Names are part of those patterns. For this reason, naming decisions should be deliberate, functional, and consistent with the overall architecture, not merely reflective of template convention. Chapter 6, Banking Implications of Poor Trust Design. How to read this chapter. This chapter is not about how to open bank accounts. It is about understanding why banking systems respond the way they do. Banks do not analyze private philosophy. They analyze structure, consistency, and risk signals. Most banking problems attributed to the system are actually responses to architectural confusion upstream. Why banking reveals what paperwork hides. Trust structures rarely fail at the moment they are drafted. They fail when they are used. Banking is the first environment where roles are tested, separation is observed, control is inferred, and activity becomes visible. This chapter explains why banks often expose architectural weakness that documents alone conceal, and why poor banking posture is usually a design failure, not a banking problem. What banks actually evaluate. Contrary to popular belief, banks do not evaluate philosophical positions, private declarations, sovereignty claims, or internet theories. They evaluate risk and clarity. Banks look for who controls the account, who benefits from the funds, what activity is occurring, whether roles are consistent, and whether the structure makes sense operationally. If those elements contradict each other, scrutiny follows. Why trusts are often rejected or restricted. When banks hesitate, freeze, or terminate accounts, it is usually because the trust appears to be operating. The trust appears to be personal proxy. The trust lacks clear governance, or the trust functions contradict its activity, or the authority and benefit are indistinguishable. These are architectural signals, not accusations. Important reframe. Banks do not create trust problems, they reveal them. Banking systems do not evaluate private intent, philosophy, or belief. They respond to visible structure, consistency, and risk signals. When banking outcomes feel unpredictable, it is usually because the trust design is sending mixed signals, not because the trust is unlawful. The most common banking mistakes in trust structures: using the wrong trust to bank. Students frequently attempt to bank through the administrative trusts, birthright trust, or the estate-centric fiduciary trust. These trusts are not designed for daily transactions, payroll-like activity, service revenue, or vendor payments. Banking activity here collapses neutrality, collapsing authority and control. Banks become concerned when one individual signs everything, no governance documentation exists, and there is no distinction between personal and fiduciary control. Without governance, banks default to personal control assumptions, commingling funds across functions. Examples include personal expenses paid from the fiduciary account, operating income flowing into a holding trust, or asset sale proceeds mixed with service revenue. Commingling is not just a tax issue, it's a risk signal. A common quiet failure. A trust may be lawfully created and properly documented. No issues appear at formation. The problem arises later, when banking systems must classify activity. If administrative, holding, and operating roles are blurred, the bank is forced to treat the trust as a single risk profile. What feels like a banking problem is actually delayed architectural feedback. Why banks require clarity? Banking systems are designed to manage exposure, not intention. They rely on clear answers to simple questions like, who controls this account? What type of activity is expected? And what does risk reside? Or where does risk reside? When trust design cannot answer these questions cleanly, friction occurs, even when no wrongdoing exists. Why the Patrick Devine framework is often misbanked. In the work associated with Patrick Devine, the 98 EIN Birthright Trust is administratively first, fiduciary in nature, and non-operational. Problems arise when students use the 98 Trust as a checking account, route business income through it, treat it as a personal bank, or skip financial segregation. This misuse may lead banks to treat the trust as a personal operating account. How proper architecture stabilizes banking. Sound architecture makes banking uneventful. This typically includes operating activity contained in operating entities or operating trusts, holding trusts remaining passive, administrative trusts coordinating, not transacting, clear governance documentation, and predictable transaction patterns. When function matches activity, banks will relax. The role of governance in banking confidence. Governance is not paperwork theater. It includes resolutions authorizing accounts, defined signatory authority, clear fiduciary roles, and documented decision processes. Structures with governance experience fewer disruptions, maintain account continuity, and avoid unnecessary inquiries. This is why family office or a trust management company functions matter, even when not legally required. Why banking problems are usually design problems. When students encounter account closures, compliance reviews, repeated questioning, or refusal to open accounts, the instinct is to blame the bank. In reality, banks are responding to signals created by poor separation, incorrect trust usage, overloaded fiduciary structures, or lack of governance. Fixing the bank rarely fixes the problem. Fixing the architecture does. Caveat: banking is not the place to test theory. Educational clarification. Banking systems respond to observable behavior, transaction patterns, and control signals. They do not validate theories. If a structure cannot survive ordinary banking, it is not ready for advanced use. Why this traces back to structure. Banking friction is rarely isolated. It almost always traces back to earlier design decisions, collapsed functions, undisciplined naming, unclear authority, or presumed or premature layering. Banks respond to what is visible. Architecture determines what becomes visible. And in closing, why banking is the first stress test. Banking is not hostile to trust, it is revealing. It reveals whether separation is real, whether authority is disciplined, whether activity is contained, or whether architecture makes sense in practice. When banking posture aligns with design, stability flows. When it does not, collapse begins quietly. This chapter exists so students recognize banking friction as feedback, not failure. Banking outcomes are not moral judgments. A bank questioning or declining a structure does not mean the trust is invalid. It means the system requires clarity before assuming risk. When trust architecture is clean, banking becomes predictable, not because banks are friendly, but because signals are consistent. This chapter exists so banking outcomes are understood as feedback, not as failure. Part 3, layering and sequence. Why more structure is not the same as better structure. Chapter 7, when layering is appropriate and when it is reckless. Why this chapter requires caution. This is the chapter where many students move too quickly. After learning about separation, authority, and structure, it is natural to assume that adding layers is the next logical step. In practice, layering is where most private structures fail, not because layering is wrong, but because it is applied without necessity. How to read this chapter? Layering is not a goal. It is a response. Every layer must justify its existence by solving a problem that already exists. If no such problem exists, layering is not protection. It is noise. When layering is often misused. Layering is attractive because it feels protective. Students often ask, how many trusts should I have? Should I add another layer for safety? Or isn't more separation always better? These questions are backwards. The correct question is, what function exists that cannot be safely contained in the current structure? This chapter explains when layering is architecturally justified and when it is reckless. What layering actually is. Layering is the intentional separation of function, risk, authority, and activity across distinct structures. Layering is not repetition, duplication, or cosmetic restructuring. Each layer must exist to solve a specific problem. If no problem exists, layering creates one. Why appropriate layering is rare. Layering becomes appropriate only when activity increases, risk concentrates, or separation can no longer be maintained within a single structure. Most students do not encounter these pressures immediately. When layering is added too early, it solves nothing and complicates everything. Legitimate reasons to add a layer. Layering is appropriate when there's new activity introduced as a new risk. Assets require insulation from operation. Authority must be separated from benefit. Banking posture requires containment, and governance cannot be maintained internally. In these cases, layering reduces exposure. Why reckless layering feels safe at first. Reckless layering rarely feels reckless. It feels organized, it feels advanced, or it feels like preparation. The danger is that every unnecessary layer introduces new explanations, new inconsistencies, and new opportunities for collapse without adding real protection. Illegitimate reasons to add a layer. Layering is reckless when it is added just in case, it is copied from someone else's structure, it is added to feel more private, it exists only on paper, or it duplicates an existing function. Redundant layers confuse banks, blur authority, increase alter ego risk, and collapse separation through complexity. The trust stack fallacy. One of the most damaging myths is the idea of a trust stack. Layer trust on top of trust on top of trust. This approach fails because authority becomes circular. No layer has clear purpose. Governance becomes impossible, and control appears centralized. Systems interpret this as the same person controlling everything through proxies. A simple layering filter. Before adding any layer, ask what existing function is failing to remain contained. If the answer is unclear, the layer is premature. How Patrick Devine structures are commonly overlayered. In the framework associated with Patrick Devine, students often add trusts above the 98 birthright trust, add holding functions inside banker trusts, and add operating layers where none are needed. This does not enhance protection, it destroys the clarity that makes the framework work. The Patrick Devine structure is intentionally narrow. Layering should only occur outside of it, when function demands. Layering versus governance. Many students add layers when what they actually need is governance. Governance can often preserve separation, control activity, document authority, and prevent misuse. Adding a trust management company or a family office function is often a better solution than adding another trust. The cost of reckless layering. Improper layering results in banking refusal or termination, inconsistent filings, loss of fiduciary posture, administrative confusion, and increased scrutiny. These outcomes occur even when documents are valid. Architecture failed, not legality. Why layering often recreates earlier mistakes. Reckless layering often reintroduces the very problems this volume warned against: collapsed functions, naming unification, unclear authority, and alter ego risk. Without discipline, layers multiply confusion instead of containing it. Caveat: if you cannot explain the layer, it should not exist. For educational clarification, if a student cannot clearly explain why a layer exists, what function it serves, what risk it contains, and what it must never do, then the layer is unnecessary and dangerous. In closing, why fewer, clearer layers are stronger? Protection does not come from quantity, it comes from clarity and restraint. A structure with fewer layers, clear roles, disciplined governance will outperform a complex structure built from imitation. This chapter exists to slow students down before they overbuild. Layering is a response, not a milestone. Layering does not signal progress. Correct layering signals necessity. Well-designed structures grow slowly. Poorly designed structures grow quickly. This chapter exists to ensure that when layers are added, they're added with purpose, not regret. Chapter 8, Sequence Errors that Collapse Otherwise Valid Trust Structures. Why sequence errors are so common. Sequence errors are not legal violations, they are timing mistakes. Most students do not collapse structures because they acted improperly. They collapse them because they followed advice out of order. This chapter explains how valid components fail when assembled incorrectly, and why correcting sequence is often simpler than undoing structure. How to read this chapter? This chapter is not about what to build. It is about when things are placed into use. When trust structures fail, not because of their design, but because functions are activated before they are supported. Why order matters more than intention. Many structures fail even when the correct trust exists, the documents are valid, and the intentions are sound. The failure point is sequence. Sequence determines which authority is recognized, which layer bears the risk, which activity is visible, and which posture is inferred. This chapter explains why doing the right thing in the wrong order produces collapse, and how sequence errors quietly undermine trust architecture. What sequence actually means. Sequence is not about dates on paper. It is about when authority, activity, and risk are introduced. Sequence answers what exists first, what activates next, what remains dormant, and what must never be activated together. Architecture is not static, it unfolds. Why this error goes unnoticed. Sequence errors rarely create immediate consequences. They often appear to work at first. The system responds only when later steps rely on earlier foundations that were never properly established. The foundational sequence, conceptual versus administrative. A recurring source of confusion is failing to distinguish between conceptual order, what exists by law, and administrative order, what is first used. The correct understanding is the estate exists conceptually by law. The 98 EIN birthright trust is first administratively. Financial interfaces come later, and operating activity comes last. Reversing this order misplaces authority. How errors compound. Once a structure is placed into use out of sequence, later decisions are forced to compensate. What begins as a small timing issue becomes additional explanations, unnecessary layers, and reactive corrections. This is how otherwise valid structures become fragile. Common sequence error number 1, activating operations too early. Students often begin business activity before governance exists. Open operating accounts before separation is clear, and contract publicly before fiduciary roles are documented. This forces systems to infer. This is a personal operating enterprise. Once inferred, correcting posture becomes difficult. Common sequence error number 2, banking before architecture. Opening bank accounts before functional roles are defined. authority is documented, or activity is assigned to the correct layer, results in improper account usage, commingling, banks assigning control to the individual. Banking should follow architecture, not precede it. Common sequence error number 3, layering before need. Adding trust just in case, or because someone else did, or to feel more protected before a functional need exists, creates redundancy, circular authority, confusion in governance. Sequence requires necessity, not anticipation. Common sequence error number 4, introducing assets before containment. Placing assets into administrative trusts, fiduciary-only trusts, or operating structures prematurely exposes assets to operational risk, banking scrutiny, or alter ego analysis. Assets must be placed after containment exists. How Patrick Devine structures are commonly disordered. In the work associated with Patrick Devine, the sequence is intentionally narrow. Students collapse it when they add operating activity to the 98 trust, introduce banking before fiduciary discipline, or build above the core before understanding it. The framework fails not because it is wrong, but because it is rushed. Why sequence errors are hard to see. Sequence errors do not invalidate documents immediately. They do not trigger instant enforcement or often appear to work at first. They surface later through banking problems, administrative notices, loss of credibility, or failed enforcement attempts. By the time symptoms appear, correction is complex. Why correction is often misunderstood. Most students attempt to correct sequence errors by adding more structure. In many cases, correction requires restraint, not expansion. Understanding what should not yet be active is often more important than adding something new. Why sequence errors mirror earlier mistakes. Sequence errors often recreate functional collapse, naming unification, authority confusion, and reckless layering. The difference is timing, not intent. Architecture fails when order is ignored. Caveat: sequence is a discipline, not a shortcut. Educational clarification: you cannot fix sequence with paperwork. You can only fix it by stopping, realigning, and proceeding correctly. Speed is the enemy of architecture. Order determines stability. Every structure rests on sequence. When steps occur in the correct order, even simple structures remain stable. When order is reversed, complexity increases without strength. This chapter exists so students can pause, reassess, and proceed deliberately, rather than reacting to problems that were created by timing alone. In closing, why patience preserves structure. Trust architecture rewards restraint. When authority is established first, governance exists before activity, assets are introduced deliberately, layers are added only when required, structures stabilize. Most failures occur not because students did too little, but because they did too much too soon. Chapter 9. Why more trust does not equal more protection. Why this assumption persists. When students encounter a complexity or uncertainty, the instinct is to add protection. In private education, protection is often mistaken for quantity. This chapter exists to correct that instinct. More trust does not automatically increase protection. In many cases, they do the opposite. How to read this chapter? This chapter is not a critique of trust. It is a critique of excess. Protection is not created by accumulation. It is created by correct placement of function. The illusion of safety through quantity. One of the most persistent misconceptions in private trust education is the belief that adding more trust automatically increases protection. This belief is understandable. More documents feel safer, more layers feel private, more complexity feels sophisticated. In practice, the opposite is often true. This chapter explains why unnecessary trusts weaken protection, increase scrutiny, and collapse otherwise sound architecture. Protection comes from separation, not quantity. Protection is achieved when functions are clearly separated, activity is contained, authority is disciplined, and assets are insulated. None of these outcomes require a large number of trusts. They require correct placement. Adding trust without adding separation accomplishes nothing. Why this feels intuitive? Adding trust feels like adding layers of insulation. Each new trust appears to place more distance between the individual and exposure. The problem is that distance without clarity creates confusion, not protection. How excess trust increase risk. Each additional trust introduces another point of control, another banking profile, another governance requirement, and another opportunity for error. When those trusts do not serve a unique function, they blur the authority, multiply contradictions, increase alter ego risk, and confuse banks and counterparties. Complexity without purpose is a liability. What excess actually introduces? Each additional trust introduces more explanations, more consistency requirements, more naming decisions, more banking interpretations, and more opportunities for contradiction. Protection weakens when explanation replaces function. The more is better fallacy. Students often assume if one trust provides protection, 5 must provide more. This logic fails because protection does not scale linearly. Risk compounds with mismanagement, and governance does not improve automatically. 5 poorly governed trusts are weaker than 1 well-governed structure. Redundant trust and circular authority. One of the most damaging outcomes of excessive layering is circular authority. This occurs when Trust A appoints Trust B. Trust B controls Trust C, and Trust C feeds authority back to Trust A. Circular authority obscures responsibility, makes governance impossible, and signals proxy control by one individual. Systems interpret this as the same person controlling everything through intermediaries. How this impacts the Patrick Devine framework. In the framework associated with Patrick Devine, the core trusts are intentionally limited. Problems arise when students add trusts above the 98 birthright trust, or duplicate fiduciary functions, or introduce holding or operating roles into administrative trusts, and stack trusts without governance. This does not strengthen the framework. It undermines the clarity that makes it work. A restraint check. Before adding another trust, ask what specific function is not currently contained. If the answer is vague, additional trust will not help. when fewer trusts are actually stronger. Structures with fewer trusts often bank more easily, maintain cleaner records, preserve fiduciary posture, and survive scrutiny. Strength comes from clear role definition, disciplined conduct, proper governance, and minimal but sufficient architecture. Elegance beats excess. The role of governance as a substitute for excess layering. Many students add trust when they actually need better record keeping, clearer authority delegation, oversight mechanisms, and separation of personal and fiduciary conduct. Governance tools such as the trust management company or family office often solve these issues without adding another trust. Caveat: complexity is not a defense. Educational clarification: complexity does not confuse systems, it clarifies risks. Systems respond better to simple structures, clear functions, and predictable behavior. Overbuilding is one of the fastest ways to invite scrutiny. Why excess structures often recreate risk. Excess trusts frequently recreate alter ego patterns through naming repetition, banking friction through unclear roles, and sequence errors through premature activation. What appears protective at the surface often undermines separation underneath. In closing, why restraint is a form of protection. Protection is not created by accumulation. It is created by thoughtful design, function separation, disciplined governance, and correct sequence. Students who learn to stop adding structures unnecessarily preserve flexibility, credibility, and stability. This chapter exists to prevent students from overbuilding themselves into failure. Protection is structural, not numerical. Protection does not increase because structures multiply. It increases when boundaries are respected. Well-designed systems remain simple longer, and poorly designed systems become complex quickly. This chapter exists so students stop building and start discerning. Educational example: Patrick Devine structure with functional expansion. Structure versus use, clarify. The Patrick Devine series, particularly Series 1, introduces students to more than just one trust. Or more than just trust. It introduces capacity and status education, estate logic, administrative process, financial interface concepts, asset protection considerations, and governance awareness. As part of that education, students are also introduced to concepts such as the holding trust, the trust management company, and a PMA. This has led many students to assume that all these structures must exist immediately. That assumption is incorrect. This example exists to clarify when structures are introduced educationally versus when they should come into play functionally. Baseline structure. What exists first? Before any expansion, the Patrick Devine framework rests on a minimal structure baseline. This baseline is sufficient for establishing fiduciary capacity, anchoring authority, and understanding administrative process. Conceptual foundation, not a document, which is the estate. This exists by operation of law. Source of authority and standing, and not created by filing, not an operating structure. The estate exists regardless of paperwork. Layer 1, the 98 EIN Birthright Trust, the first administrative instrument. Its role is to the first trust created administratively, fiduciary administrative expression of the estate, and it anchors capacity and commerce. What it is used for is administrative interface, fiduciary positioning, and capacity expression. What it is not used for. It is not used for operating businesses or holding operation assets, delivering services, or acting as a personal account. This trust must remain narrow and non-operational even though it is foundational. Layer 2, the private banker or a private individual banker trust role is for financial interface. What it is used for is to receive funds, disbursing funds under fiduciary authority, and it maintains financial discipline. It is not used for asset holding or operating activity, or governance or service delivery. At this stage, structure is intentionally minimal, even though education is broad. Where additional structures come into play as needs arise. The Patrick Devine series introduces additional structures early for comprehension, but they are not automatically activated. For example, the holding trust when assets exist. Introduced in Series 1 for understanding, but functionally used only when there's real estate is acquired, long-term assets need insulation, or operating risk must be separated from ownership. Why they do not come first. There's no assets equals nothing to hold. Premature holding trusts create alter ego risks. Holding trusts are situational, not functional. For the trust management company, when governance is needed, introduced early to explain fiduciary discipline, but functionally used only when multiple trusts exist. Trustees need formal oversight. Record keeping and compensation must be formalized, or personal conduct must be clearly separated from fiduciary action. The TMC solves governance problems, not structural ones. It is added when complexity demands discipline. The Private Membership Association, or PMA, when services begin, introduced to prevent misuse of trusts, but functionally used only when education, consulting, or services are offered. Membership activity begins, or revenue is generated from services. The PMA exists to keep service activity out of trusts, prevent fiduciary structures from becoming operating businesses. It is not part of the estate or fiduciary chain. Why this distinction matters. Students often expand structure too early because they confuse educational introduction with functional necessity. The result is overbuilt systems, banking problems, alter ego exposure, and collapsed fiduciary posture. This volume teaches restraint so students understand. Just because a structure is taught does not mean it should be activated. The key principle. Patrick Devine teaches a broad private administrative education. The structural footprint required to support that education is intentionally narrow. Additional structures exist to support assets, governance, and services, not to validate status or authority. For expanded clarification, the estate, EINs, and the 60 series misunderstanding. One of the most common points of confusion for students is the belief that the estate itself must be set up with an EIN immediately, often assumed to be the 60 series EIN. This confusion is understandable because estate EINs are discussed throughout Patrick Devine's Series 1. Examples frequently reference a 60 series number. Students see filings and assume the estate must be activated early. This section exists to clarify what the estate is, when an EIN applies, and why most students misunderstand the timing. What the estate actually is revisited. The estate is the origin of authority. the source of standing and the aggregation of rights, interests, and property. The estate exists by operation of law. It does not require an EIN to exist. It does not transact on its own, and it does not open bank accounts by default. In other words, the estate is real before it is administrative. Why students believe the estate needs an EIN? Students believe an estate needs an EIN because they observe references to 60 series EINs, estate level correspondence examples, or executor and fiduciary filings, and treasury and administrative interfaces. What is often missed is why those EINs appear. The EIN is not for the existence of the estate. It is for the administration of the estate when administration is required. The correct role of a 60 series EIN in Patrick Devine's teaching is the 60 series EIN is associated with estate administration, not estate existence. A 60 series EIN is used only when the estate is acting administratively in a way that requires identification. There is a need to interface with institutions as an executor capacity. Estate level administration is occurring, not merely conceptual authority. It is not required simply because the estate exists. Critical distinction: conceptual estate versus administrative estate. This distinction resolves most confusion. Conceptual estate is the exists automatically, source of authority, and no EIN required and no filings required. The administrative estate comes into play when administration is required. It may require a 60 series EIN used for executor level interaction. Contextual and situational. Most students attempt to administratize the estate prematurely, believing it must be activated. That is incorrect. Why the 98 EIN birthright trust still comes first administratively. Even though the estate is the origin of authority, Patrick Devine teaches that the 98 EIN trust is the first administrative instrument because it provides the fiduciary interface without administratizing the estate itself. It allows capacity to be expressed without premature estate filing, and it preserves the estate's conceptual posture. It also avoids unnecessary EIN issuance. This is intentional design. Why the series shows the 60 series later? Throughout Patrick Devine's Series 1, the 60 series EIN appears in the executor level context. It is introduced once students understand capacity, process, and restraint. It is shown in relation to specific administrative acts, not blanket setup. Students often miss this nuance and assume if it appears later, I should do it now. This volume exists to prevent that mistake. Common student errors, what this volume corrects. Students often apply for a 60 series EIN immediately, attempt to open estate bank accounts prematurely, and treat the estate as an operating or banking entity. Also duplicate EINs unnecessarily and collapse estate and trust functions. These actions do not strengthen authority, they create confusion and exposure. The key principle: the estate does not need an EIN to exist. It only needs an EIN when it must act administratively. Patrick Devine teaches the availability of estate administration, not the obligation to invoke it immediately. Part 4, Practical Discernment. Chapter 10, Common Guru Structures and Why They Fail. Why this chapter is necessary. This chapter is not about discrediting individuals. It is about identifying recurring structural patterns that fail regardless of intent. Many popular trust structures circulate because they appear to work initially. Their failure is often delayed, not immediate. This chapter explains why certain designs repeatedly collapse when placed into real-world use. How to read this chapter. The structures discussed here are not wrong because they are creative. They fail because they collapse function, confuse authority, or ignore sequence. The goal is recognition, not criticism. Why copying structures is the fastest way to collapse them. One of the most damaging habits in private education is structure copying. Students encounter diagrams, charts, or screenshots online and assume if it worked for them, it will work for me. If it's more complex, it must be stronger. Or if it's being taught, it must be required. This chapter exists to explain why many widely promoted private structures fail, not because they are illegal, but because they are misapplied, misunderstood, or overbuilt. The goal here is not to attack teachers, it is to teach discernment. The trust stack model, what is commonly promoted, multiple trust layered vertically, circular control paths, no clear distinctions between administration, holding, and operation. Why it fails? It fails because authority becomes circular, no trust has a clear purpose, governance becomes impossible, and systems infer proxy control by one individual. This model collapses under basic scrutiny because function is never defined. Why this structure appears to work at first? This structure often functions initially because no conflicting pressure has yet been applied. Problems emerge later when banking, contracting, reporting, or dispute resolution requires clear separation of roles. The delay between setup and failure is what makes the structure attractive and dangerous. The everything runs through the trust model. What is commonly promoted, one trust for banking, business, assets, services, and personal expenses. Why it fails is alter ego analysis and unavoidable. Banking posture contradicts fiduciary neutrality. Assets become exposed to activity, and personal and fiduciary roles collapse. This is not asset protection, it is centralization disguised as separation. Why this structure appears to work at first? This structure often functions initially because no conflicting pressure has yet been applied. Problems emerge later when banking, contracting, reporting, or dispute resolution requires clear separation of roles. And the delay between setup and failure is what makes this structure attractive and dangerous. The activate everything immediately model. What is commonly promoted? Immediate filing of the estate EINs, multiple trust EINs, UCC filings, and notices and affidavits. Why it fails? Premature administrative posture, unnecessary exposure, inconsistent records, and loss of flexibility. Architecture rewards restraint, not urgency. Why this structure appears to work at first? This structure often functions initially because no conflicting pressure has yet been applied. Problems emerge later when banking, contracting, reporting, or dispute resolution requires clear separation of roles. The delay between setup and failure is what makes the structure attractive and dangerous. The name it correctly and you're protected model. What is commonly promoted? Heavy emphasis on all caps formatting, special words or phrases, and declared status in names. Why it fails? Names are treated as signals, not magic. Poor naming increases alter ego risk, and over-declaration attracts scrutiny. Protection comes from function and conduct, not labels. Why this structure appears to work at first. This structure often functions initially because no conflicting pressure has yet been applied. Problems emerge later when banking, contracting, reporting, or dispute resolution requires clear separation of roles. The delay between setup and failure is what makes the structure attractive and dangerous. They all do the same thing. The more EINs, more authority model. Applying for a state EINs immediately, multiple EINs without function, or EINs to activate authority. Why this fails? EINs identify administration, not existence. Excess EINs create confusion, and authority is inferred from conduct, not numbers. This misunderstanding is addressed directly in this volume. And they also conflicting because it appears to work at first and then later does not work. The banking first model. What is commonly promoted? Open accounts before governance exists. Roles are defined or activity is assigned. And it fails because the banks infer personal control. Improper usage patterns are established early and correction becomes difficult later. Banking is a stress test, not a starting point. Same thing here. Because you have conflicting pressure has yet been applied, problems emerge later when you try to do the banking and all that fun stuff. Where Patrick Devine is often misrepresented. Much of the confusion surrounding Patrick Devine's work comes from misrepresentation, not from his actual teachings. Common distortions include expanding structure instead of understanding process, treating administrative education as structural instruction, conflating remedy theory with operational design, and copying outputs without learning discipline. When this happens, failure is blamed on the framework instead of the misuse. How to evaluate any structure you encounter? Before copying any structure, students should ask, number 1, what function does each layer serve? 2, what risk does this layer contain? 3, what activity is permitted here? 4, what must never occur here? And 5, what governance preserves this separation? If these questions cannot be answered clearly, the structure should not be copied. Why these failures are predictable? These failures are not random. They follow the same patterns described throughout this volume: collapsed function, undisciplined naming, premature layering, and misplaced authority. Different labels do not change underlying architecture. Why imitation is so tempting. Students copy guru structures because they promise certainty. When a structure is presented as complete and authoritative, it feels safer than building understanding. The problem is that certainty without context replaces discernment with dependency. Education is not instruction to act. Educational clarification. Learning about structures does not obligate you to build them. Understanding process does not require immediate execution. This volume exists to restore judgment, not urgency. Why these structures fail under pressure. Most guru structures collapse not at formation but at interaction points like banking, contracts, disputes, or administrative review. These pressures expose structural shortcuts that were invisible during setup. In closing, why discernment is the real skill. The most successful private systems are not the most complex. They are understood, disciplined, governed, and restrained. Students who learn discernment stop chasing diagrams and start building coherent, durable architecture. This chapter exists so students learn to recognize failure before they copy it. Why understanding beats replication. Structures fail not because they are unconventional, but because they are misunderstood. This chapter exists so students stop copying outcomes and start understanding architecture. True protection is built, not borrowed. How to evaluate a trust structure without drafting one. Why analysis comes before action. Most structural failures occur before a single document is signed. They occur when students copy diagrams without understanding function, draft before clarifying the authority, file before defining activity, and build before governance exists. This chapter teaches a critical skill: how to evaluate a trust structure on paper, mentally, and conceptually without drafting anything at all. This protects students from premature filings, structural contradictions, overbuilding, and banking and alter ego risk. The first question: what problem is this structure solving? Every valid structure exists to solve a specific problem. Before evaluating layers, ask what risk is present, what activity exists, what assets require protection, and what authority must be expressed. If a structure cannot clearly answer what problem it solves, it should not exist. Function mapping. Assigning roles before documents. A structure must clearly assign administrative function, the coordination, records, and oversight, the holding function, passive ownership, and operating function, the activity and contracts. If one layer attempts to perform all three, collapse is inevitable. Evaluation rule is one function per layer. Authority tracing. Where does power originate? Students must trace authority upward, not downward. Ask, where does authority originate? Who is acting in a fiduciary capacity? Is authority documented or merely asserted? Is there governance supporting the authority? Authority that cannot be traced cleanly is assumed to be personal control. Activity containment. Where does risk live? Every structure must answer, where does activity occur? Where is risk accepted? What absorbs the liability? If activity is spread across administrative trusts, holding trusts, and estate-level instruments, the structure is already compromised. Asset placement. What must remain passive? Assets must be evaluated separately from activity. Ask, does this asset need insulation? Is it exposed to operational risk? Is it placed where activity occurs? Assets placed in active structures lose protection regardless of how many trust structures exist. Excuse me, one moment. Naming and appearance. How does this look externally? Evaluation must include appearance, not just intent. Ask, do names suggest unity of interest? Does everything point back to one individual? Would a third party infer alter ego control? If appearance contradicts separation, separation will not be recognized. Governance check. Who maintains separation over time? Even a perfectly designed structure will fail without governance. Ask, who maintains records? Who enforces boundaries? Who documents decisions, and who prevents convenience from collapsing roles? If the answer is the same person informally, governance is insufficient. Evaluating structures taught by others. When reviewing structures taught by others, including those associated with Patrick Devine, students should separate education from execution, concept from structure, and process from paperwork. Patrick Devine teaches a broad administrative education supported by a narrow structural footprint. Misunderstanding this distinction is where students get into trouble. The no drafting rule. This chapter imposes a discipline. If you cannot explain the structure clearly without drafting it, you are not ready to draft it. Drafting should be the final step, not the first one. Evaluation is not inaction. Educational clarification. Deliberate evaluation is not avoidance, it is risk management. Most irreversible mistakes occur when students act faster than they understand. Why discernment is the real protection. Students who learn to evaluate structures, avoid overbuilding, preserve authority, maintain banking stability, protect assets more effectively. This skill prevents failure before it happens. Architecture is not built with documents first, it is built with judgment. Chapter 12. What must be understood before any trust is created? Why creation is the last step, not the first. By the time students reach this chapter, they have seen the pattern. Trusts do not fail because they are invalid. They fail because they are created before understanding exists. This chapter exists to draw a clear line. If the concepts in this chapter are not understood, no trust should be created yet. Creation is not progress if it produces instability. Understanding authority versus administration. Before any trust is created, students must clearly understand authority originates at the estate level. Administration is how authority is expressed, and documents do not create authority, they document it. If a student believes authority comes from EINs, filings, declarations, or trust names, they are not ready to create a trust. Understanding function before form. Every trust must answer one question clearly. What function does this trust serve that no other structure currently serves? If the answer is vague, such as asset protection, privacy, control, or just in case, then the trust should not be created. Function must be specific, limited, defensible, and necessary. Understanding what the trust must never do. Equally important is understanding what the trust must never be used for. Before creation, a student must be able to state what activity is prohibited, what assets must never be placed here, what authority must remain outside this trust, and what behavior would collapse separation. Trusts fail most often by overuse, not underuse. Understanding sequence and timing. Before creation, students must understand what exists conceptually versus administratively, what comes first, what must remain dormant, and what must wait until necessity exists. Creating a trust too early is not neutral. It can force premature banking posture, invite unnecessary scrutiny, and collapse fiduciary neutrality. Sequence is a discipline, not a technicality. Understanding governance obligations. A trust is not self-governing. Before creating a trust, students must understand who will maintain records, who will document decisions, how separation will be preserved, and how convenience will be restrained. If governance is informal, inconsistent, or personal, the trust will become an alter ego regardless of drafting quality. Understanding external perception. Intent does not control outcome. Before creation, students must consider how banks will perceive the structure, how names signal control, how activity patterns will be interpreted, and how authority will be inferred. If the structure looks personal, it will be treated as personal. Understanding the difference between education and execution. This volume and others like it introduce many concepts. trust types, administrative tools, fiduciary rules, and governance models. Understanding these concepts does not obligate execution. As discussed earlier, even in frameworks associated with Patrick Devine, the educational scope is broad, while the structural footprint is intentionally narrow. Students must resist the urge to build everything they learned. The readiness test. The student is ready to create a trust only if they can answer all of the following without hesitation. Number 1, what specific function will this trust serve? 2, what risk does it contain? 3, what activity is allowed here? 4, what activity is prohibited here? 5, where does authority originate? 6, how will governance be maintained? 7, how will this appear externally? And 8, why does this trust need to exist now? If any answer is unclear, creation should be postponed. Delay is a form of protection. Educational clarification. Waiting is not failure, it is restraint. Many of the most serious errors in private trust work occur because students acted before understanding stabilized. In closing, why readiness is the real foundation. This volume was not written to help students create more trust. It was written to help them create fewer trust, create the right trust, create them at the right time, and use them correctly once they exist. Trust architecture is not about paperwork. It is about judgment and under restraint. When students reach this point with clarity, the next step, creation, can finally be taken without collapse. In conclusion, from architecture to readiness, this volume was intentionally restrained. It did not provide templates. It did not provide instruct immediate action. It did not encourage building for the sake of building. Instead, Volume 2, The Trust Architecture, taught students how to think structurally before anything is created. By this point, students should understand why most trust structures fail, why separation matters more than paperwork, why sequence determines stability, why overbuilding increases risk, and why governance is more important than clever drafting. Most importantly, they should now understand what not to do, what this volume was designed to prevent. This volume exists to prevent students from copying trust diagrams without understanding its functions, creating multiple trusts without necessity, prematurely filing EINs, including estate EINs, using fiduciary trust as operating businesses, collapsing identity, authority, assets, and activity, and blaming frameworks when misuse causes failure. If a student finishes this volume and feels the urge to go build everything, the volume has not yet done its job. What readiness looks like now. After completing Volume 2, a student should be able to explain the role of the estate without trying to activate it. Explain why the 98 EIN birthright trust is administratively first. Identify when a holding trust is actually needed and when it is not. Recognize when governance, not another trust, is the solution. And say not yet confidently without fear of missing out. This architectural maturity, how the family office fits from here. At this stage, many students recognize a gap. They understand structure, but not yet governance. That gap is intentionally addressed in the Family Office series, which focuses on administration and discipline, record keeping and resolutions, role separation in daily life, and oversight without collapse, preventing convenience from undoing structure. The family office is not another trust. It is an operational discipline that preserves everything learned here. This is why it is introduced at this stage, before students attempt advanced private remedy or enforcement education. What's next? Volume 3, Status, Capacity, and Administrative Posture. Understanding how you are seen before you act. If Volume 2 taught you how structure fails, Volume 3 teaches you why people fail inside otherwise sound structures. Most students do not lose protection because their trusts were invalid, their EINs were wrong, or their documents were missing. They lose protection because they misunderstand status, capacity, and posture. Volume 3 exists to correct that. Why Volume 3 comes next? Trust architecture answers what should exist, what must be separated, and what should not be built prematurely. But it does not answer who is acting, in what capacity, and how that action is interpreted administratively. Why intent is irrelevant without posture. Those questions are addressed in Volume 3. Before any trust is created, funded, banked, or used, students must understand how systems classify behavior, not belief. What Volume 3 teaches? Volume 3 focuses on status literacy, not sovereign claims. Students will learn the difference between status and capacity. Why claiming status does not create authority. Why administrative systems respond to form, not theory. And how misusing language collapses private posture. Why silence, restraints, and precision matter more than assertion. This volume dismantles status correction myths, all caps name theories, over-noticing strategies, misuse of affidavits and declarations, and belief-based approaches to authority. Why this volume is critical before any execution. Students who skip this step often assert authority instead of exercising it. Overfile notices, misuse affidavits, and trigger administrative attention. Collapse neutrality through overexposure. Volume 3 teaches how to exist in private capacity without announcing it. This understanding is required before trust funding, banking activity, administrative correspondence, estate-level action, and advanced private education. How Volume 3 relates to other series. Volume 3 remains part of the Private Foundations and Risk Literacy series. It does not replace trust architecture, does not initiate remedy, and it does not teach enforcement. It prepares the student for governance education, like the Family Office series, advanced fiduciary administration, and Patrick Devine level education without misapplication. The purpose of this transition is Volume 2 taught you restraint in building. Volume 3 teaches restraint in being. Only when both exist does private work become stable. And that is it for tonight. I hope you all enjoyed it. If you viewed our video, please subscribe, like, and share. Tomorrow we start our PMA series, and that will be an 8-week class, as well as Thursday the Patrick Devine Series 3 Executor and Equity series will be an 8-part series. And we will see you guys next Tuesday for another live of Private Path HR Solutions. You guys have a good night.